May I be permitted to move a writ appeal tomorrow or day after tomorrow? It is already filed, my lord.
Why do you need to mention it?
It was filed on 15th.
Then it will come. Don't give the detail.
My lord, the only thing is tomorrow, day after tomorrow.
Give the detail.
It's already given, my lord. 15/12 it was filed.
No, give details to the court.
Did, yeah. Did.
Next.
May it please your lordship. Lordship, with the consent of all the parties, I beg to mention item number 19 to 24 of the today's, this matter may kindly be taken after the vacation. We had to file a objection to the report of the district council. We could not file it.
At the request of Mr. Surat. 30th of January. Next. Yes.
May please lordship, I beg to mention for item number 4, my lord. Further 4 weeks time may be granted for filing the affidavit. But I am unable to collect the certificate.
Granted.
My lord,
We are giving you a lease of life.
after
covered matter.
4 weeks, my lord,
It is a covered matter.
my lord.
Against,
Our own judgment.
My lord.
against you.
My lord,
We are not grandsons.
my lord, death certificate, I want to collect that.
Do you understand? We are not grandsons.
Grandson.
So we understand why you are asking for time.
No, my lord.
Huh.
They want to file the additional
That
affidavit.
is
with
what
the
we are
death
saying,
certificate.
that we are not grandsons.
My lord, grandson, my lord, the Assam Accord, some
Next.
commissioner.
Anyway, so it is in a lighter way. Yes, come to
May I please, Lord. On last item number 16, on the last occasion, your lordship granted us time to file our objection regarding the report of the district judge.
yes.
Lord, we have sent it for waiting. We require some more time. If it come up, we can come up, my lord, in the last week of January.
That water diversion.
My lord.
Tin
Have the consent from
to care. Tin to care.
Golaghar.
Golaghar. Any date. 23rd January. Next.
23rd.
May please your lordship. Item number 18 may be come up after vacation manner. I had taken the consent of petitioner also, madam. Item number 18.
You have to file affidavit.
Affidavit, we have received the instruction and sent for meeting, madam, immediately after vacation, madam.
Next.
Mass Public, please your lordship, with the consent of the other side, I beg to mention item number 39 of the daily list. Lordship, it may be taken up after the vacation as my senior is after vacation today.
39.
39.
Service is not complete. Wait. We will pass order of fresh notice. Wait till it is called out. Yes, anybody else?
May I please your lordship? Lordship, with the consent of other side, I like to mention item 43, your lordship. Matter may come after vacation or
Okay.
much public.
30th January. Call out. Ready? Okay. So, right. Mr. Mahmood, your matter has come, but probably the corpus may not be brought because of our order.
If it can be taken at 2 p.m., my lord.
No, 2 p.m. we may not be able to convey to the police. Because the date, there was a typographical error as you mentioned this matter has come. Do you understand? We may keep it tomorrow.
Tomorrow.
And ask the police to bring the corpus. That would be Mr. Nath. The corpus is here.
But lordship normally takes up at 2. She is coming at 2.
So she will come at 2. And then we will take up at 2 o'clock.
2 o'clock. Today.
Yes, today.
Obligement.
Item number 2 of daily list.
Who appears for the government in this?
On the last occasion, the Lordship had directed him to file an affidavit. Did not
Yeah.
file, Your Lordship.
Who appears for the government? Bhattacharya ji. Is there? Mr. Bora. Last time he was asked to file affidavit. The respondent authority shall comply with the order dated 21/11/2020 by the next date of hearing. Adjourned to. Next.
Item number 3.
Is it pending before the learned single judge?
My lord, that is pending, but the issue therein, my lord, somewhat different. My lord,
Now we can take a different view and
no, my lord, what I'm trying to say.
we
that is in-
already adjourned it last time because of that. When
Well,
is
I-
it coming?
I mean, what I'm trying to say, I only want one observation.
Hmm.
My lord, your lordship may decide this case, my lord. The issue before the learned single judge is in respect of appointment of a secretary. Now, he has challenged, my lord, here, the election, man, saying that election should not be held because they would be disqualified. Now, my lord, there is a division bench judgment which says, my lord, if the fall cannot be attributed to them, they can participate in the election.
No,
So,
no,
my lord,
that might be so, but last time also we had made it clear that it was adjourned because of pendency before the learned single judge.
The lordship may fix the date, my lord.
No, but when is it coming before the learned single
You
judge?
will just be there.
That it was not reached, my lord. Depth of a matter.
But when is it
But date
listed?
is not listed.
My lord, can I have an observation from your lordship regarding disposal of that, my lord, writ petition as expeditiously as possible? Because otherwise, my lord, the mandate of the law, my lord,
Learned single judge is
3391/22.
number 91 of 2022
2022.
is pending. It's requested to dispose of to hear the same as expeditiously
Vale.
as possible. Adjourned to 23rd of January.
Man, obliged, man, deeply obliged.
Item number 5.
Yes, Mr. Majmudar.
Yes.
See, we were thinking aloud before you begin. Once you exercise the power under section 48,
My lord.
now it may be a technical defect in your exercising the power.
My lord.
Therefore, you have two options. Either you declare before the court by way of some document
My lord.
that it was abandoned at the stage of declaration of section 6 notification,
My lord.
or you have to process the application.
My lord, yes, my lord, I have done some research.
Please tell me.
My lord, 1998 is the first judgment.
Hmm.
Thereafter 1988, I'm just handing over these judgments. to you. Lordship, may kindly have a look at this
No, no,
1998.
judgments may help us. There is no doubt about it.
My lord, I'm just indicating. There is a reference of Gujarat High Court judgment in 1988. In that case, my lord, there is a reference of 1966 Supreme Court, which makes it very clear. Lordship, making it straightway look at paragraph 20 of that 66 Supreme Court panel. In fact, it could be either rescinded or before this notice under section 9 is issued, my lord, under the Land Acquisition Act 1894, it could be rescinded or cancelled. So far as our decision is concerned, my lord, decision was taken to withdraw the notification under section 4 itself.
Yes.
If that is so, my lord, then 48 doesn't apply, my lord.
It would not be attracted at all.
My lord,
But now for you yourself have issued 48 one.
my lord, we issued, my lord, in fact, there was,
And Mr. Majmudar also please check up.
my lord.
This division bench judgment is our high court means my high court judgment is dealt with.
Right.
There has to be an application by the acquiring authority. Because this is not a acquisition where 17.1 or 17.4 were applied.
Yes,
Then the case would have been different.
Right.
Here is a case where section 4, probably if you go deep into the matter,
Right.
it may not have reached the section 5 stage itself. That is what my intuition is after reading the matter.
my lord, if you, my lord, Lordship is absolutely correct. Lordship, may kindly permit me to read one paragraph from this 1966 Supreme Court panel.
No, I'm conscious about it.
My lord.
I'm aware of it.
Ma'am.
Not that I want to prevent
Ma'am.
you from hearing, from reading. The question is that then there is strong exercise of power by the government under section 48(1).
My lord.
Probably the army as an acquiring officer, acquiring body must have written you to withdraw from acquisition, which has been interpreted as withdrawal under section 48.
Absolutely, my lord. You're absolutely correct. Army has it simply intimated us that because of the status of the land, because it is
Whatever
low
may
lying,
be the reason.
we do not
because-
require it any longer.
because That needed for public purpose is evaporated
My lord.
as provided under section 4. But then how will you rescind from this?
My lord, what I am saying is, my
You
lord,
will have to come out with another notification.
absolutely, my lord, absolutely. My lord, our decision was to withdraw the notification under section 4 itself.
Therefore, it really technically, it should have been termed as abandoned.
Abandon.
Abandon.
My lord, Supreme Court says you can either rescind it or you can cancel it.
Cancel it.
My lord, my difficulty is, my lord, although the decision of the government was to withdraw the notification itself, but because of the paragraph 100 of the manual of land acquisition of Assam, my lord, it says the next procedure is to undertaken under section 48. Mistake lies there, my lord. It is because of that 48(1) notification was issued. My lord, Lordship, may I kindly permit me to read one paragraph from this 1966 Supreme Court, my lord. Para 20. Very interesting, my lord. Very interesting, my lord. 66 doctor is taken, my lord.
Yes.
Then reliance is placed on section 48, which provides for withdrawal from acquisition. The argument is that section 48 is the only provision in the act which deals with withdrawal from acquisition, and that is the only way in which the government can withdraw from the acquisition. And unless action is taken under section 48(1), the notification under section 4(1) would remain presumably forever. This was the argument, my lord. It is urged that the only way in which the notification under section 4(1) can come to an end is by withdrawal under section 48(1). We are not impressed by this argument. In the first place, under section 21 of the General Process Act, the power to issue a notification includes the power to rescind it. Therefore, it is always open to government to rescind a notification under section 4 or under section 6, and withdrawal under section 48(1) is not the only way in which a notification under section 4 or 6 can be brought to an end. Section 48(1) confers a special power on the government of withdrawal from acquisition without considering the notifications under section 4 and 6, provided it has not taken possession of the land covered by the notification under section 6. In such circumstances, the government has to give compensation under section 48(2). This compensation is for the damage suffered by the owner in consequence of the notice under section 9 or any of the proceedings thereafter, and includes costs reasonably incurred by him in the prosecution of the proceedings under the act relating to the state land. The notice mentioned in subsection 2 obviously refers to the notice under section 9(1) to persons interested. It seems that section 48 refers to the stage after the collector has been asked to take order for acquisition under section 7 and has issued notice under section 9(1). It does not refer to the stage prior to the issue of the declaration under section 6. Section 5 says that officer taking action under section 4(2) shall pay or tender payment for all necessary damage done by his acting under section 4(2). Therefore, the damage, if any, caused after the notification under section 4(1) is provided in section 5. So there are two types of damages, my lord.
That is why I'm saying,
My lord.
see, Mr. Majmudar,
My lord.
last time, if you recollect,
My lord.
I had taken you to subsection 3 of section 6.
My lord. I remember.
This is the difference,
Behind.
because it doesn't become free of encumbrances till it reaches subsection 3 of section 6.
My lord.
Therefore, 48 is provided.
Yes.
Therefore, the words used by the legislature even in 1894 is withdrawal.
My lord.
Release is not there, only in 5. This is the interpretation.
My lord.
So you will have to come with a notification under section 5,
Yes, ma'am.
and you will have to rescind this.
Rescind.
Because
My lord, the whole submission before lordship is, my lord.
in a lighter when Mr. Majmudar, some retired officer of your department, has helped the appellate.
My lord, my only submission today,
I used to receive many such briefs when I was at the bar.
my lord,
So I
My
can
lord,
make out.
my lord, for the purpose
Find
of
out a way out, otherwise government will be settled with interest to
huge burden. my lord.
interest means
My lord, my submission before your lordship at this stage will be, my lord, because of the pendency of this petition, my lord, undertaking an exercise of that nature, whether it will amount to proceeding or taking up any parallel proceeding or not, my lord, there are some Supreme Court judgment which says when the court is in session of the matter,
but
why do you do?
you will
So
have to,
some observation, my lord, from your lordship
Mr. Majumdar, you will have to bring all this on record to enable us.
by
to-
filing a repeat, my lord, I'll file,
Ah.
I'll file. Let me first file, then I'll ask for that observation, my lord,
Otherwise, it will be,
my lord,
we can't do it so much.
my lord, my lord.
Because at the first blush, this reaction and my intuition is proved to be correct, that it was not dealing with the factual background of the acquisition proceeding. Loosely worded petrol may entail government into
Consequence,
crores of rupees.
Yes, pro,
Please give this judgment to that.
lordship will give us some time, 10 days time, my lord, we'll file. it.
Any date that you want.
Well, first week of January, lordship. In the meantime, some exercise has to be undertaken.
Take your chance on both. Next.
Obliged.
Matter number 6,
Yes, Mr. Puyan.
My lord, may I pleases your lordship. My lord, this matter, my lord, is relates to, my lord, the TET qualification. My lord, conducted by the, my lord, the state in the secondary education department for the various madrasa educational institutions, my lord,
Hmm.
existing at that relevant period of time, my lord. My lord, now this madrasa education system has now been abolished by the government. And these all madrasas, my lord, had been converted into general schools. My lord, the plea taken before the learned single judge, my lord, was that, my lord, the government initially, my lord, after conducting the madrasa TET examination, my lord, due to, my lord, scarcity in the general TET qualified candidate, my lord, decided to appoint the teachers from this madrasa TET pass candidates, my lord. Now, my lord, when the process was going on, then only, my lord, this state has conducted the TET for the general school. For the secondary level as well as for the upper primary level also, my lord. Now, my lord, when this TET was conducted, even then also, my lord, the government has decided to, my lord, man this madrasa TET qualified candidate in general schools with the same qualification of madrasa TET. But, my lord, when this selection process was going on, my lord, then suddenly they have come up with a notification in the year 2019 that due to the structure and course curriculum and syllabus of the madrasa TET examination is something different with the general level school. So therefore, both the class cannot be treated at par, my lord. And accordingly, my lord, they have cancelled the, my lord, notification by which this madrasa TET qualified candidate had been, my lord, accommodated or allowed. My lord, that decision had been challenged before the learned single judge. And the learned single judge, my lord, has upheld the decision of the government, that the decision which has been taken by the government is, my lord, distinct, and both the classes are different. So, my lord, therefore, one class cannot be treated with the other as at par. My lord, that is the issue, my lord, has been, my lord, we have challenged in this appeal, my lord. Some hearing is required, my lord, and today, my lord, I have some health issues, my lord, not fully fit, my lord.
Any date that you,
My lord, please after the vacation, my lord, and the first week of January, my lord. Oblige, my lord.
matter number 7,
Mr. Advocate General, now that it is we want adjournment, therefore we are not, otherwise. Are there any schools which are imparting Hindi and Hindi medium in this type of school?
Hindi medium schools are there in the general system. Now the government madrasas which are there after 1994 Act, which was set, which we have repealed in 2020 and which was challenged, and this honorable court also upheld our decision, and the matter is now pending before the honorable Supreme Court.
Supreme Court. That is
So
why
far as those
it is-
madrasas,
It is the same matter,
My lord, yes, my lord.
because I had read somewhere in the newspaper. also.
Yes, my lord. The decision of this honorable court, my lord, has been assailed before the honorable apex court, and that is pending. My lord.
Notice is issued.
Notice has been
No, my
issued.
lord, leave had been granted, my lord.
I'll leave.
Yes, yes, my lord.
Leave that.
Obliged.
May I please, your lordship?
item number 7,
Citation list, Mr. Majmudar, you are there?
Yes. So the gradation list prepared, sent to the government. My instructions are that the names of the petitioners are not there in the promotion, in the proposal for promotion. Otherwise, they are there in the gradation list. The gradation list is finalized.
They are part of the gradation.
Gradation list,
My
yes.
lord,
They could not make it a merit.
our names are present in the gradation list in the.
They have continued, but you are not eligible for promotion. That is
No,
what-
my lord. As per the gradation list of 2021, my lordship,
Hmm.
our names has been recommended and just after we filed the case, my lordship, our names has been dropped. New
No.
gradation list has been.
No, you please turn to your prayer. In the read petition.
Yes. In the read petition, my lordship,
Page number 38.
gradation list, my lordship, cannot be changed, my lordship.
Please turn to page 38, sir.
Yes, my lord. Intentionally, our names has been dropped from the new gradation list.
No, it has not been dropped. That is what he says.
No, my lord.
That is my
Gradation
instruction.
list, I have annexed, my lordship.
You better,
I'll
Wait,
file an
wait, wait,
affidavit
wait,
bringing on record the gradation list and
my
the
lord. The, our names are present in the main gradation list. After we file the case, our names has been dropped.
Here is 30th of January. Next,
item number 8,
yes, Mr. Na.
So they filed an affidavit, my lord.
We have not received it.
My lord.
Today,
In the court.
my lord, we have filed today. Can it be taken up tomorrow, my lord? Because he has got some urgency, he has been showing urgency.
Tomorrow we'll find it. He must we may keep it on 2nd of
My lord,
January.
2nd of January.
Can it be on the last day, my lord, 22nd, my lord, if possible, my lord. My lord, and since my lord, since March, my lord, I'm behind.
I may tell you,
My lord.
I was conscious about this fact. Even 2nd January, it would be, I would be texting myself, but I would text because he is behind the bar.
2nd January. As your lordship pleases.
And I don't know whether you will argue that ground or not, but we have one ground is our.
My lord, your lordships gave enough indications today. But we have to file the affidavit. We have filed.
No,
it
you
today.
file it,
My lord.
2nd January.
My lord.
April.
item number 9,
Here also, Mr. N. Das was to file affidavit.
May it please, your lordship.
Mr. Das, N. Das. Opposition was to be filed last time, it was made clear. Mr. N. Das requested for time.
Government
Government,
council.
where is Mr. N. Das? Where is N. Das? Next. File affidavit in reply as per the earlier order dated. Time is short. Next,
item number 10,
Lord, may I pray for take up this matter after the victory?
otherwise on merit, there is nothing in this
My
matter.
lord, if one attempt I will make, try to satisfy. Obliged.
Next. It was in our gradation list of to be dismissed, but you want time, we grant you time. Next.
My lord, my lord. Obliged.
item number 45 of supplementary list,
Have you checked up that
Yes.
judgment?
I've got 3 judgments.
Uh, तुमको dating कहाँ है? Yes. एक नोट तो है? Forward. There are later judgments also.
That's it.
There are later judgments on this point. So I'll find out. There are directly on this issue. These are little old.
Yes,
older
sir.
ones.
These are all 2008, 9 and
It is
10.
2019. SCC. Let it come before another page.
Look.
My brother may have some.
Look.
Action. Next.
Matter number 46.
Before my learned friend starts, my lord, a copy may be given to me, my lord. I am appearing on behalf of this 14-year-old minor class 9 student of Sainik School, Gwalpara, my lord. A copy of the writ may be given to me, my lord, so as to assist your lordship, my lord. It can be taken up.
My lord, my lord, we have urgency, my lord, because.
What urgency?
Yes, my lord.
Then start arguing. Have you heard them?
Yes, my lord.
Have you heard the student?
My lord.
Have you given any hearing to the student?
Yes, my lord. And my lord, another aspect is here, my lord.
Don't
May I-
tell yes without reading the papers, ma'am.
May I point out, my lord, another
Huh?
aspect?
Huh?
Another aspect is there, my
No,
lord.
no aspect,
My lord,
no
hearing
other
has-
aspect.
My lord, hearing has been, that has opportunity has been given, my lord.
No.
Kindly see, my lord, page number.
You read para 11 of the judgment. 10 and 11. Para 15.
Para 15.
Para 15. Thus,
That-
upon the due consideration of the case in its entirety, I am of the considered view that there has been gross violation of principles of natural justice. You
My-
suspended him, there is okay. Suspension can be there without hearing.
Yes, my lord.
The case against you is that you forced the parents to ask for transfer certificate.
That is not the case.
But it's a disputed question. We will not go into it.
Yes, my lord.
But as far as their going out is concerned, you have not heard them.
No, my lord, that is, we have that, office note, or office record also, my lord.
Your office record may be your endorsement. You chose the hearing part.
Yes, my lord. That SCOD committee has taken the statement of that, all the petition and all.
That taking statement is no hearing. You have suspended him from the school.
My lord, the case is that
Did you give any notice to him?
there, my lord, they have that of they have the power, my lord, under section 3.332 of my.
Where have you argued all this before the learned single judge?
Yes, my lord, I have argued that also, my
Then
lord.
file a review before the learned single judge.
Because, my lord, kindly see,
Where have you argued this? There is no whisper about it in the judgment. Then file review before the learned single judge. You can't be permitted to argue a new case in the appellate forum.
And-
Unless and until it's a question of law.
my lord, there is also a question of, may I?
It is a
point out-
mixed question of law, in fact, whether you have heard or not. You have not even issued notice to them. Suspension, yes, it can be done overnight. You ask them to stay home.
My lord, before suspension, they have given that transfer, the application for transfer certificate.
That itself shows that, madam, we are also conscious what type of discipline this particular school has.
Yes, my lord.
Understand?
So-
But they are amenable to law. They may be strict. They may be army. That doesn't make any difference. Even if it is a Sainik school. They have to follow the law.
Here, my lord, that,
So if you want to find out a way out in this, take instructions from your client.
my
If they
lord,
are-
client is here, may I
No.
Take instruction from him that suspension will continue. We have seen him sitting there. There is no other army matter today, so we could make out that therefore we told you.
Yes, madam.
Suspension will continue. But you have to hear them and pass an appropriate order. We are dealing with the career of some students. We should be little soft and lenient also, but not at the cost of discipline. Your school has a special discipline. I also belong to a state where a similar school is situated since years, decades. So I know the discipline of that school. I am personally aware about. Even to my knowledge, before independence it is there. So your officer is there, take instruction. Otherwise, even if we admit the matter, we will not be able to grant you stay.
Sir.
You can address the council.
No, please come, please.
My lord, can we continue to the suspension order, my lord?
Yes,
Then, my lord,
now read para 10.
yes, my lord.
Even if you agree, please para 10, so you may not make the same mistake. Read para 10 of the judgment. And take back this file.
Para
Please-
10.
Yeah, please,
Yes.
please give it. Please read that so that you have. If we,
I have
I also perused the report produced by so and so.
I have perused the record produced by the London wherein there is a report made by the Standing Committee of Discipline of the school recommending the withdrawal of all students who were found to be involved in the incident, including the petitioner students who were before this court. The report was laid before the principal and principal approved the recommendation made by Standing Committee and asked for preparation of draft withdrawal letter to be put up. However, before the withdrawal letter could be issued, the transfer certificate issued to the petitioner student. My lord.
Now, therefore,
Yes,
what
ma'am.
you are showing us was a prior decision taken by the standing committee.
Yes.
At that moment, no hearing has taken place. So learned single judge has not guessed through it. We could get through it even while reading the judge. This is what has happened. Meanwhile, they, according to you, they volunteered to have transfer certificate. According to parents, they were forced to that either you are thrown out or you ask for transfer. This is what actually has happened in reality. No parent would be ready to, they put his or her son or daughter or ward in such a difficulty. So suspension will continue. We don't want to have any exemption for the discipline of the school. But the standing committee will have to give an opportunity to the parents, because they are all minors. Call them, hear them, and then take a decision.
My lord, my exams are on March.
But therefore, we are in December.
If they continue the suspension indefinitely, my
Suspension
lord,
will continue.
one academic year will be lost, my lord.
But it was
Because
when you committed that mischief, you should have understood.
But record proved that there was nothing committed by me, my lord.
It is a part of the inquiry, sir.
Part of the inquiry.
But I'm a class 9 student, my lord. I'm at a very crucial juncture of my life, academic career.
Sir, we come across matters of even 5-year LLB students. Where is advocate general? Majmudar is there. Today only that matter is there.
This is just a 14-year-old boy, my lord. Just a 14-year-old small boy.
I don't know whether you were mischievous or not. I can't say anything about me.
Because these are not, my lord, criminals or direct terrorists, my lord.
I understand, but procedure is to, this is Sainik school, sir.
I deeply appreciate, my lord. But
Therefore, they will do it within a period of 1 month.
because if one month also I have to sit at home, my lord, I'll be losing out on classes, my lord.
So,
May I just suggest a way out, my lord? May I suggest a rational way out?
इतना तो होगा.
एक छोटा सा मतलब रिक्वेस्ट है, my lord.
हाँ.
मेरा रिक्वेस्ट ये है कि बच्चों को क्लास करने दीजिए. अगर दे सक्सीड इन दी अपील, I'll be out from the school anyways.
We don't
At
want,
least बच्चे को class करने से तो class 12 अभी 12 का exam है my lord.
if you agree, we may pass this order, otherwise we'll admit you up.
I'll leave it up to your lordship.
No, don't leave it to us.
Or
It is.
or because or your lordship will allow me to file an affidavit explaining my stand in the
Then
writ
then
appeal.
we'll take the order.
Your lordship can take it tomorrow. I'll file it today itself. my lord.
We are, if time is money, then we don't have anything.
If your lordship takes up the writ, just now I got a copy.
Therefore,
It would require a hearing. Why
it
don't
would
you
require a hearing. If you don't agree, it will require hearing.
So your lordship will be referring the matter to the single judge for a review.
No. We are asking the standing committee of the school to hear you and decide to issue.
Let it be within a time frame, my lord.
1 month.
1 month, my lord. This is December. January will be, March is the exam.
We are on 19th of December. They will decide by 19th of January.
That your lordship will,
Your primary ground is that you are not given an opportunity of being heard.
That
Yes.
we are providing.
and the second ground is that in that,
Do you want a hearing to be conducted in 48 hours?
my lord, that is not what I'm suggesting. All I'm
1
suggesting,
month is a reasonable time.
all I'm suggesting, let them take due course of law. Let them at least, let the students resume classes, my lord. They're missing out on the classes.
All missed, yeah. So and so. Admit. I liquor by an interim order, the interim judgment is stayed.
That will create a huge prejudice, my lord.
But then you file your reply.
In that case, my lord, your lordship will find the 1 month.
No, now you file
Because
reply.
it will-
We don't
it-
want to have,
One academic year will be lost of the students, my lord.
therefore we were with you. We were trying to find out a way out.
My lord, in that case, your lordship will kindly,
Don't hesitate. You file your reply. There's no problem.
it's a 14-year-old minor, my lord.
He may be minor. Students are always minor. Full students.
There, for nothing, even the records prove nothing before the single judge, my lord.
But we have to look into it, sir. You are parent. We are not parent.
In that case, my lord, kindly, my
We
lord,
are only guardian.
in that case, kindly, my lord, let it
No,
be.
don't concede. We don't want you to concede. File your reply. Have satisfaction of hearing. There is no difficulty.
But if
We
your
are
lordship,
keeping it immediately after the reopening. So we are only issuing notice.
let it be immediately after the review.
Notice.
1 second, my lord.
Example on 18th of January. Till then,
Let it be my
judgment.
second January.
No. Impugned judgment shall state. Shall remain state. Next.
The number 11 of Delhi list.
Yes, Mr. Nath, what is the position?
Malad, I tried my best, Malad. I have no information as regard any CBI case. Malad. I have also made a contact with the standing council of CBI. I have no information. They are not,
Nothing in state of Assam.
no, not in state of.
Will you be able to make that statement?
Malad, the standing council CBI, I have also given the information to him.
Who is the standing council?
Mr. S.C. Kayal.
Huh?
Mr. S.C. Kayal.
Oh, yeah.
Yes,
Can you request him to remain present at 2 o'clock?
Lordship. Well,
Come at 2 o'clock. Because we will not permit him to withdraw the bet.
Right.
It's PIL. Generally, we don't.
Item number 12.
Right.
Yes, Mr. Kokia. Mr. Kokai.
May it please the lordship.
Yes,
First, we
Councillor
want to
Singh.
withdraw this PL
Next.
matter. With the liberty to approach the district telecom committee matter if required.
Next.
There's no power otherwise.
There's no bar.
Yes, my lord.
Next. Considering the issue involved, it is the request made by Ms. P. Baru. First council is hearing for the R. Baru.
Arbor, my lord.
R. Baru. Also considering the fact that the mobile tower is already constructed. Withdrawal is submitted. Petition state post office. Next.
Number 13 and 14.
May it please the lordship. I think that the affidavit has come on record, my lord, perhaps.
Do not have a
By which, by June 2023, the plant will be commissioned. They have filed an affidavit.
It is in a separate file, so we could not have, we
Lot-
have not,
Lord,
we'll just look at. One
Lord,
second.
Lord.
Say, on one end, they say it is 12 months and done it educated.
Yes, 12 months, it should have been completed by 31st of March. As per the contract agreement with the person.
No, if you read para 4. Okay, page 330, it was given when,
LOA given 9/5/20.
because
In the contract, it was 12 months. In the yes, Lordship, I have reading. As per the
one
letter of
year
acceptance
would be over in May.
is progressing smoothly
No, 1 year would be over in May.
in May, Lordship.
So you will be able to do it by June. That is what we are saying.
It is on time, works are progressing, Lord.
Progress.
Yes, that is why the commissioner himself has filed his
That
affidavit.
is why we are indicating that
Lord.
if you want, we may say July, so that.
It will be better, but we are quite confident, Lordship, till as per the
then
and
we'll do
next 5 months, Lordship, which is the construction season. We
Ah.
don't have any difficulty now,
That I forgot.
Lordship.
Mr. Das, then anything else is to be recorded? I don't think.
No, there is nothing because this is the last important thing that is required in this matter, my lord. The plan, solid waste management plan.
4 orders,
Okay.
Deeply observed.
because we will have to narrate everything, so,
It's true, my lord. I understand.
and that order is ready, you will get it in the 2 o'clock.
Neramek. Jail order.
Deeply observed.
Much obliged.
Item number 15.
तो हो जाएगा तब तक 8 months के ऊपर you were to examine this also, Mr. Das.
Yes, they have filed the criminal petition against the order passed by the, against the order of discharge, yes, my lord.
Let it be pending then.
Lordship, let us see, my lord.
Next. 30th of January. Then council is appearing for the party. Submission, further actions are. Further actions are taken by the state of Andhra Pradesh. Arunachal Pradesh. Whereby the order of discharge has been valid
My lord.
and adjourned to 1st February.
My lord.
Next.
Deeply observed.
Item number 17.
Steps are to be taken. You have to
Maybe.
take these steps which you have not taken.
No, my lord. If Lordship may kindly look into my lord, office note dated 15/12, my lord. 15/12.
Hmm.
One SR Nath, my lord, under the seal of DGM, he accepted notice on behalf of the respondent number 13.
Fifteen, 12, 2020.
My lord? Yes. 15/12. Office note date.
पूरा फाइल करो आके ऑफिस नोट सब किए so 13 is out. Let somebody appear. Call somebody from the district, give this file to him and either he does it in the court. Not your job. No, you don't do it. Call them. Next.
Item number 25.
Yes, Mr. Nath, what is the status?
But Lordship has directed us to issue an SOP, that has been done.
You send this to the public prosecutors also.
But today I have received this. Definitely, we'll send it. This will be circulated through.
No, but PFF station is already constructed.
Stations, 20 stations are functioning.
Is let Mr. Mohanto be there.
Lordship, he has some personal difficulty today. His father has been admitted in the hospital, Lordship. He has not come today.
Will it be available day after tomorrow?
Lordship, I don't know. Lordship. Let it be fixed in the first week of January, Lordship,
For January.
of life, Lordship.
Item number 26.
Service not affected. Service not complete.
There was repeated occasion, madam.
What?
On repeated occasion, we have taken notice, madam, but service is awaited, madam.
Wait, sir. Next. Wait, sir. January. Next.
Item number 27 to 30.
In this matter, I have taken the instruction of the petitioner and the respondent office are trying their level best to solve the grievances, your lordship. So, lordship pass the necessary order, your lordship.
What necessary?
Yes, lordship, I received the affidavit in opposition filed by respondent number 2, your lordship, para number 7, your lordship. The deponent begs to state that there are illegal traders trading on this footpath, which causes obstruction to the public on movement of pedestrians, which cannot be denied. And subsequently, some steps taken, para number 9 and para number 10.
Who appears for the corporation?
Lordship, I am appearing for JMC Lordship. As per your Lordship direction, we have already filed another affidavit, Lordship, but probably that is not in the record, Lordship. Second affidavit.
No, but any scheme is there?
Or I'm sorry,
Scheme for the street vendor.
street vendors, Lordship, I have in the second affidavit, Lordship, we have given a list there, Lordship. We have specific vending zones, Lordship, as per GMC's notification,
But
Lordship.
do you implement that?
We are trying to implement, Lordship. We are in fact
Trying to implement moving forward. You have to implement that.
not yet.
If you don't implement, then there is no, it is only a paper tiger.
No, we are implementing, Lord.
I have not seen in this 6.5 months.
That particular road, Lordship, this is not in the notice, Lordship.
I have never seen.
Lordship, in fact, in the second affidavit, Lordship, we have given a list, Lordship.
Let that affidavit be on record.
Lordship.
You filed in the first proceeding 15 of 2021. Which matter have you?
PIL 15 of 2021.
Call for. Day after tomorrow.
Apply.
What about other matters, Mr.? What about other matters which are connected with it? Other matters are also connected with it.
Yes, Lordship, connected.
What is to be done with that?
Lordship, pick up those matters also along with it.
But who appears for that?
But JMC, Lordship, I'm prepared for it.
I'm from petitioner.
We'll take up separate. Next. Day after tomorrow.
Item number,
You see, Mr.
Next.
Marshal, there is this writ petition of 2014 that requires a reply from you. We don't mind keeping it day after tomorrow.
Item
Because
number-
now there is a special act which requires a local authority to or the state government to have a policy for this. This is what we are telling you.
Got
EIL can be disposed of because now the petitioner is not interested. We take it that way. First. But this is a petition which requires consideration by your authority.
Lordship.
It is a separate issue. It is a converse issue. Therefore, there has to be a comprehensive submission by the GM. EIL, you can get it disposed of. There is no difficulty.
Got it.
But what about the street vending? Because that scheme requires approval of the state government. Is writ petition 5042 of 2014. Please see the prayers in that. Please we'll take only 1 minute. Please see the prayer straight. Page 13. Please see the prayer. This is converse petition. Don't evict them till you implement the direction of the apex court order.
Not yet.
Now, there is not a whisper about it in this petition. You will have to take proper instructions. Please take proper instructions.
Not yet.
Let it come after vacation. In 2 days, you will not be able to do it. Please remember this. 5042 of 2014. Because as the record unfolds, this was before the learned single judge, which has been now tagged along with it.
Not
So
yet.
it may escape your attention. Are you having the file of this?
Lordship, I am having the file, Lordship. On the next date, Lordship, I will open my.
Give some date in January. Next. Now all the matters, because within 2 days it won't be possible.
item number 31,
We'll fix the matter. We'll fix the matter. Give some date.
Yes.
List 2 on 23rd of that. Next. Next.
Matter number 32.
As instructed by orally instruction of this honorable court, we have informed the other side also. The matter has been listed today. Now, this is basically a state has filed an appeal against the learned single judge. Order dated 25th of January 2021, because the direction and the impugn judgment is not sustainable both in fact and law, because
But,
this is against the ratio laid down by the Honorable Supreme Court.
Senate Council, we can take up ex parte matter like this.
Lordship, I beg your pardon.
Nobody is appearing for the other side.
Despite of the information, last occasion,
No, I understand.
yes.
Let
So we leave it to the Honorable.
we'll admit the matter. What admit? Heard Miss
Additional
Dr. Sumya, yeah,
Dr. Doma T. Bhutia, Additional Advocate General for the state of Sikkim.
equal advocate. No doubt, no one appears for admit. Next.
Matter number 33.
It is adjourned to with date Lordship.
Now you will get the date. We have admitted the matter.
That is admitted for hearing.
Much obliged, Lordship, much obliged.
So in this case, I'm seeking some time. The Home and Political Department is seeking some information from the district authority. This is regarding dismantling some houses in Nagaon district.
Not
Lord.
dismantling. Don't say dismantle.
Lord.
If it would have been dismantled, this growth would not be here. When do you want?
On 3rd of January. Lord.
No, I have no sentiments about this matter. I have already expressed myself,
Lord.
which is known to almost the whole world by now. So it was reported everywhere.
So on 3rd, Lordship, maybe take a final call on this, Lordship. I'll come with the answer.
Next.
Obliged. Matter number 34.
May it please, my lord. In this case, I have to file affidavit in reply, my lord, filed by the number 1, my lord.
The picture is emerging, Lordship.
What?
The
What
picture is
affidavit now?
the picture is very
My
clear.
lord, affidavit filed by the respondent number 1, my lord.
What affidavit now? Nothing.
Yes,
It is
regarding my lord.
PIL.
Yes, my lord.
You have been given the access. The matter ends there.
Yes, my lord.
What we told is there.
And the bond is also not used for public purpose.
If, my lord, there is a
Incorrect
way
statements
for-
are being made
to
before this one.
agricultural land, my lord, then we have no objection.
And to the agricultural land, there are 3 other ways.
For orders. Nothing doing.
You have to go by your prayer.
I read something about it in today's newspaper also.
Lord.
I don't know, I forgot. There is some reference to this. Next. Unnecessarily after,
Matter number 35.
yes, Mr.
Well-
Dina,
Order has been complied with, my lord. We have given the appointment letter, my lord.
okay,
Yes, my lord.
Much obliged.
Obliged.
next.
You have a copy of that.
I have already furnished a copy of the appointment letter.
You place it on record.
Yes.
So and government council place it on record, the order of the fund. Stated so and so. In view of the same, the court could not survive. The proceeding stands closed. Next,
Obliged.
Highly obliged, my lord.
next.
Matter number 36.
Lordship, if I may, Lordship, may kindly pass over the matter for a time being.
In fact, madam, this order, this writ appeal can be disposed of by a similar order passed by your lordship in another writ appeal, my lord. Where your
Lordship,
lordship
there's a
will,
slight different tangent to it, Lordship, if I may, Lordship, after some time.
Because Mr. Chaudhary appeared.
Mr. Will sort it out.
That is the change.
Right, Lord. No, Lordship, there's a tangent, Lordship, if I may, Lordship, actually, Lordship.
the earlier writ appeal your lordship has disposed of.
This
in
one
making-
number 4 is unsolved, Mr. Chaudhary.
Yes.
R4 is not solved.
That is my-
You appear
yes, yes.
day after tomorrow.
Now, let-
Next,
Matter number 37.
Yes, learned education.
There was a little delay on my part. I have taken the steps, madam. The students are allowed to sit in the exam. They are sitting in the exam
Then what met, now nothing remains in your appeal.
in the appeal. Madam.
Should have briefed Advocate General today also, otherwise we will not pass you.
But since it was for steps, my lord,
University can't act so smart.
I know I did not trouble him because it was only for steps and there was a mistake on my part. I took it a little late, my lord.
He'll
Yes,
take
I
up only if learned Advocate General. This is unfair.
My lord,
This is unfair. See, if he had already stated that in, but you have not even south,
my lord.
they are south or not south.
The copies, my lord.
Respondents are south,
No, my lord, they're not.
then you have to south them. You are
Right.
enjoying interim.
My lord, yes, but they are for orders of this court, my lord, they are appearing in the examination. Our difficulty was allowing them to enter into the campus. When lordship had stayed that part and allowed them to participate in the deputy commissioner's office, my lord, they are regularly sitting in the examinations. There's no trouble on that.
Exams are over.
My lord, they will continue till 22nd, if I'm not wrong, and the practical examinations is one part that we are having some
But then
difficulty
you
again.
should have south them. What steps? See, Mr. Majumdar, in
Well-
such matters, you should not even give it to your clerk.
I know, no, it was not about the clerk. There was a permission for Dusty also. I had sent the copies to the university.
Hmm.
But for some, in their wisdom, they said that the exam ke beech mein we should not be giving them copies and they are sitting in the exams. Let them sit.
We
This
will
is,
vacate this order.
my lord, would not do that, my lord.
We will vacate this order. If they are appellate authorities of a division bench.
No, my lord, they are not appellate authorities, my lord.
They are wiser than the.
My lord,
court.
I have already stated, my lord, there was some delay on my part also, my lord.
Don't serve them by tomorrow.
Tomorrow, my lord.
We will vacate this order.
Tomorrow, my lord, I'll have it, sir.
Day after tomorrow.
My lord, I'll have it, sir, tomorrow. Abhilash.
Number 38.
With your lordship, service is not yet complete, your lordship.
111 and 12 are non.
Lordship, 111.
Service. Next.
Number 39.
Service incomplete. Next.
Yes, as per official note dated 15/12/22, my lord, service upon response number 1 to 7 and 9 is stay awaited, my lord.
We'll wait for this.
Letter number 40.
Here also R2 is not solved, Mr.
May it please the Lord.
Anybody appears for number 2 now?
Yes, my lord, I understand Mr. D. Nath is appearing for the competent authority. Though he is only a formal party, but your lordship wanted me to serve, we have taken steps. I can make my submissions on the application of continuation of delay. There's a delay of 179 days. A certain serious.
Please, your lordship. If this matter may kindly be passed over for a time.
Who appears?
Yes, what happened, my lord?
It is for condonation of delay. Do you have any objection?
My lord, let my senior appear, my lord.
You should have taken instructions whether he has objection or. Unnecessarily, we may have to wait. If you have objection, file your reply. Otherwise,
We'll file a written objection, man.
Huh?
We have filed a written objection.
You have objection,
We have filed a written objection.
not on report.
When did you file it?
Mr. Ganpati, you received it?
Yeah, we have received a copy. In fact, it was filed on the last date of hearing. We were served the copy in the morning of the last date of hearing.
It is not with us.
Well, my respectful submission is this. There are some serious allegations that have been made in the application, my lord. Misrepresentation was made by the first respondent when the writ petition was filed, based on which the order has been passed. 7/2/22 is the order. My lord, it will have a bearing. His knowledge of the
Mr.
acquisition.
Ganpati, first we'll have to cross this order of delay.
That is right.
Now, if they have filed affidavit in reply, you will have to counter that reply. Affidavit by filing reply. Because then this has to be heard and put to a logical end. Otherwise, we are very lenient in condoning the delay, but when there is an objection, we can't help it.
His lordship is willing to hear me, my lords, wait for Mr. Botakur, I can make my submissions even without a rejoinder. If
We don't permit such hearing
very,
because we don't know some allegation here or there, and then when we sit to write the judgment, we have to again call you that what is your reply to
very well, I leave it to the.
the, sir, what's your name, sir?
P. Sinha.
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 The P. Sinha states that the affidavit in opposition has been filed by respondent number 1. Mr. P. Nath appears for respondent number 2. 2 and 3. Reply affidavit, if any, be filed by the applicant by the next date of the hearing, 17th January. Next,
Your lordship kindly have it in the first week, my lord, subject to lordship's pleasure.
you are absolutely correct that prefix is not, prefix is more important than the date. Next,
Item number 41,
Mr. Nath, you were to file some affidavit.
But we have filed the affidavit on 17th. We have served the copy to the appellant also.
Please, the lordship. Lordship, Madam Senior Counsel, Mr. Deedas appears, he is on election 14/16.
He will not wait beyond vacation. Next,
item number 42,
yes, learned advocate general, any progress?
Lordship, regarding the land, the process has been started with the government, lordship. Because this committee, they have taken up the matter. So it will take some time, lordship, but we are on the job.
Learned advocate general D. Sakya states that the steps have been taken by the committee for earmarking the land in question. And the state exercise shall take some time. It is requested. Return to
And what to respondent 19 file an affidavit
30.
about smart.
30 January, you will have almost 1.5 months. for
Lordship.
Next.
Highly obliged.
item number 44,
May please. Actually, my learned friend is referring for the respondent. Lordship, there is no dispute with regard to implementation of the order as per the tribunal. Only our observation, Lordship, paragraph 34 to 40 may be taken into consideration while passing the necessary order fixing the seniority of the inspector. With that observation, Lordship, this may be closed. Lord. Only my learned friend has no objection.
Paragraph number
34 to 40. Lord. Of K. Mega Chandra Singh, Lordship, 2020.
number.
Lordship, page 23 judgment starts, page 126. Keeping in paragraph 5, keeping in view of the accepting the prayer made by both the councils, we remanded the matter to the department to prepare a fresh seniority list in the grade of inspector in the light of latest decision of the Honorable Apex Court in so and so.
Para 4, you are reading para 4.
Paragraph 5, Lordship,
By keeping
page
in view
126.
therefore, by accepting the prayer made by both the council, we remand back the matter to the department to prepare a fresh seniority list. Yes, what clarification? do you-
Lordship, paragraph 34 to 40 of the K. Mega Chandra Singh judgment. That is reported in 2025 SEC page 689.
No, so what clarification you want?
Lordship, our anxiety, Lordship, we may be directed to, while refixing the seniority, we should comply with the judgment of the Honorable Supreme Court, particularly from paragraph 34 to
तो
40.
वो तो लिखा ही है इसमें. It is mentioned in the case of K. Maxton Singh versus so and so Supra. It is all.
Lordship,
Why do you need that clarification?
Lordship, only the paragraph 34 to 40 may be
And
complied.
what about rest of the paragraph?
No, that is already covered because Lordship, seniority was earlier fixed. That was unsettled by this judgment. And some observation has been made in paragraph 34 to 40. Lord. Actually, that will not make any difference. Lordship.
Then what, no difference is made.
Yes, Lordship.
We'll reiterate what it has been stated.
Lord,
What is,
Lord,
do you withdraw this petition?
Lordship may dispose of with a direction to within a period of 2 weeks, we'll comply with the direction.
So we will have to justify this finding given by the Learned
Lordship, as such, there is no dispute with regard to implementation of the assessment. But at the relevant time, the Lordship Department think otherwise that unless there is a specific mention of this paragraph.
Then we'll say in our order that there is no dispute in implementation.
Not.
But the petition civil number 5389 of 2020. Called Mr. S. T. Kyle and Environment Council for the petitioner and Mr.
Yes, not for all the respondents.
By way of this petition under Article 226 and 227 of the Constitution of India. The petitioners have challenged the validity of the order date 2002-2020 passed by the Central Administrative Tribunal Court branch in original application number 40 public 21 public third of page 123. Mr. Kyle and counsel at the outset state that as such there is no dispute, but as regards the observations made by the learned tribunal, the implementation of the same is not objected or disputed. Sir, Kyle have submitted that as per the decision of the apex court in the case of so-and-so versus so-and-so quoted in 2025, SCC page 689. Specific direction ought to have been given by the learned tribunal. Inviting attention of this court to paragraph 32,
34,
34, 32 to 34,
34 to 40,
34 to 48,
40.
40 of K. Meghrajan Singh Supra. Was contended by Mr. Kyle. The tribunal ought to have directed to take into consideration those paragraphs not taken. Correct. As against this, Mr. So-and-so has submitted that the tribunal has already mentioned the judgment as a whole, and therefore no specification, clarification is required. We are in total agreement with the observations made by the tribunal. No further clarification is required. It is open for the petitioner to take into consideration the observations made by the apex court in the case of so and so Supra, more particularly in paragraph 34 to 40 by deciding the issue before it.
Much,
With this observation, the petition is disposed of. No for.
much of it.
Very. In our court. Okay.